lawyer and you have a client sitting in your office and you suspect that there is some mental health issue or some issue that's going to be a problem, I don't know why, but I usually just get a feeling, and I usually just have to bluntly ask them. And at first they deny it, and I ask them again, and I ask them again. And next thing I know, I have a client crying in my office. So you want to be ready with the name and number of a mental health professional that you can refer this client to. And it's a horrible thing. I made someone cry, and yet I may have helped their immigration case because I got the truth out, and now we can talk about it and make that mental health assessment. So I don't like to make people cry, but it happens, and it's not an easy process.
And so is there anything that mental health professional would like to get from an attorney? Is it a matter of education about mental health and immigration, or is that too open-ended of a question?
I can tell you that if I know a mental health professional is going to be doing an evaluation for a case I'm working on, I usually try and have a conversation with them about it before they get too far into it. So I can describe what are the immigration laws that are relevant to this specific case. When we do when we're submitting a waiver application and we have to show that the U.S. citizen or permanent resident, spouse, parent, or child would suffer extreme hardship, we have to do it in a two-pronged approach. We have to say, what would be the hardship to those U.S. citizen or permanent resident relatives if the immigrant was not allowed to stay here and the family decided to stay here without them anyways? On the other hand, what would the hardship be to those U.S. citizen or permanent resident relatives if the immigrant couldn't stay here and they chose to go home with their relative to the home country? And in the LGBT context, where a country might not be as friendly towards LGBT people as we are, that can be a real problem. So we need the evaluations to go both ways, so to speak.
And those are very difficult scenarios, especially looking at leaving this country as a family, which oftentimes brings on a lot of the emotional stressors out for the family, where they wouldn't even consider that as a possibility. And I think we never talk about that. They don't want to talk about that. So it takes some finesse in terms of looking at, well, what if scenarios? What would it look like for you as a family if this were to happen? If members would stay here and others would leave, or if everybody would go to the home country, and what are the hardships? And that's really where the hardships come out. And when you can see the extreme hardships, and oftentimes as a separate units of the family, they would not be able to function in any level similar to what they're doing as one unit.
And I would imagine that in the future you will see more extreme hardship cases dealing with LGBTs. Now that they're going to be able to petition for a partner, and those who have been here in the country illegally and they have to demonstrate extreme hardship, you're going to see more and more of those cases. Yes, that's something that you will see more and more.
I was just thinking about folks who are in detention centers now, so we're talking, well, seem to be talking in some cases about folks who are not in detention centers. You know, how are their mental health needs being taken care of, if at all?
I mean, I can tell you, just to give you a premise to that one, transsexuals, transgender individuals bear the brunt of the detention process. They disproportionately bear the brunt of isolation. They are in detention, they're in a 22-hour, 24 solitary confinement. And so it's going to be even more now. But go ahead. Sorry.
There's about 400,000 people on any given day in detention and immigration, customs enforcement, detention, and some of the, I mean, I think at least half of them have no prior legal, I mean, they don't have any record, right? And so you're dealing with, basically this very low-risk population that are being detained, and many of them have children, have, families, have partners, had jobs, and are, I mean, psychologically, it's ridiculous. And then on top of it, there's very little oversight for private detention. So I would definitely tell people who want to know more about it to watch Lost in Detention, which is on Frontline at Streams for free, anytime you'd like it to. And it's narrated by Maria Hinojosa, and it's a great watch, but it tells you lots about mental health abuses within the detention system.
Just to add to that, what Roberto was alluding to, I think as a matter of practice, what ICE tends to do with transgender or gay or lesbian detainees is to put them in solitary confinement for their protection. And that's how it's labeled.
For their protection.
For their protection. And I mean, a lot of these individuals are experiencing PTSD from what they suffered in their home countries. I mean, it's ridiculous, and the compounding effects of being in solitary confinement is really damaging to the mental health of these individuals, and ICE does not provide them with proper treatment.
I think we can open up the floor to any questions unless
Wanted
anybody wants.
something before detention. I want to go all the way back. One of the things, because of families having multiple immigration status, I worked in a domestic violence program, and many of the things that happen within the family dynamic in dealing with domestic violence is that domestic violence in families where the status are mixed or undocumented does not get reported, and it tends to be much more abused for fear of both partners, whether LGBT or not, of ICE coming in and then creating even more difficulties for the family.
Okay, any questions from the floor? Adriana.
When it comes to, you have a VAWA, what about a male-male couple, married couple? How does that come into play? Is it just that it may be violence against women, but it also applies to men? Or do they go a different route, or how does that happen?
Well, it would be the same route, the same legal standard. So to be more specific, if someone's applying, they're submitting a self-petition because they've suffered, because they were married to a legal permanent resident spouse or U.S. citizen spouse.
Provided their marriage is recognized as legal.
Yeah, that's assuming that. So yeah, that's a very important consideration. But let's take that as an assumption. Then the standard is the same. That spouse must show that he or she suffered extreme cruelty, and extreme cruelty means anything that tends to show that standard. So that can be financial, economic abuse. It can be isolation. It can be physical abuse. It can be a whole range of factors. And so I think whether a person, an LGBT person or not, the same factors are going to be addressed. But I think the degree to which an LGBT person suffers isolation or exclusion or those types of factors may be heightened. It probably will be in most cases. So I think in that sense, it's going to be the same standard, but I think it'll be a matter of degree in that sense.
So is it still called a VAWA application?
It's still called a VAWA.
VAWA stands for Violence Against Women's Act, but specifically in the law, it says that it applies equally to all genders. So it's not limited to violence against women.
Okay. But just practically speaking, I'll let you know that male VAWA petitions are more scrutinized than female VAWA petitions, and that has a lot to do with social stigma that, men cannot be victims of domestic violence. But it does, there can be a male petitioner under VAWA.
I had one once. His wife took a bottle and slashed his arms with it. It was physical violence. We had good proof. We won.
And the second question, if I may, completely unrelated. When it comes to, given that our armed forces are now fully integrated, so is it easier if you are the spouse of a veteran or an active military duty service member to then qualify to become a lawful permanent resident?
If it's an affirmative petition, you're simply applying for your spouse, that shouldn't matter. Everyone should be treated equally under the law. Where I could see that being beneficial is, for example, in a request for prosecutorial discretion, perhaps, where, you know, Immigration and Customs Enforcement has said that it will take into consideration family members that have been in the armed forces, things like that. But if it's a simple affirmative petition, that shouldn't matter.
I had a case once where someone needed a waiver of inadmissibility because they had entered the United States without permission and stayed beyond their time. They married a U.S. citizen veteran who suffered from PTSD. And basically, the immigrant was the glue that held that veteran together. So that was a crucial component in the mental health evaluation to show that he would suffer extreme hardship if she was not given a visa. It doesn't have to be he and she, it could be he and he or she and she, but that's, I think, the PTSD syndrome of that a veteran might be having, is where a waiver application can be strengthened greatly by the fact that they're a veteran.
And for those who are in the audience, can you tell us what PTSD is?
Post-traumatic stress disorder. It's a mental health condition experienced by people who've experienced extreme stress. Frequently in combat, but it can be from many other things as well, from experiencing torture, all kinds of things. Persecution.
And if I can just add about your question specifically about spouses, is it easier or harder? I think formally speaking, as Vanessa said, no, it shouldn't make a difference. But when we're talking about hardship, if the person needs to show that in some application, then I think the arguments can be made both ways. The argument that Mr. Myers just made is a great one. If a U.S. citizen spouse is suffering from PTSD, without his or her spouse, it's going to be, that person will probably suffer extreme hardship here without that person, because they're going to have to deal with that alone, and without the support, the comfort, the the needs of the non-citizen spouse. On the other hand, let's say that the non-citizen spouse must show that he or she suffered extreme cruelty. Well, having a partner who is in the armed forces may affect the control that person exerted over the non-citizen spouse. That non-citizen spouse may have felt more isolated because of the power position that their spouse was in, the formal power position that spouse was in. So I think arguments can be made either way in that sense.
And in the case of a veteran suffering PTSD, they may not have access, if they were required to go live in a third country, to the mental health services that they get here provided by the Veterans Administration, which is a very strong argument for why they can't go live with their spouse outside the United States, because they're not going to be treated.
Okay, and I have a question here.
Actually, it's added on to her question. What if somebody is in the military, they're abroad, and they're going to, so they have to get married in a country, they're going to have to go to Holland to get married or something like that, and then they want to come back here and coming into a state that either does or does not recognize?
My view is that combining the matter of Zeleniak case with the fact that the marriage was legal in the place where it's celebrated, it doesn't have to be in a state, it could be in a country outside the United States. If the USCIS takes a liberal view and approves the visa petition, then they shouldn't have a problem. The case is stronger if the immigrant comes from that country where the marriage took place, because that country would have an interest in setting the rules for marriage over the people that are domiciled in that country. But again, if two people go get married in a completely different country, want to sponsor someone, that's going to be a question of how does the USCIS interpret the place of celebration rule. Are they going to enforce it strictly, or are they going to look to the law of the place of domicile of the U.S. citizen or permanent resident? So that remains to be seen.
Okay, one more question here.
Hi. You guys talked earlier about how some people have problems because they can't prove that they filed joint taxes and this, that, and the other. When I came to the country in '92, I had to have an interview with my then wife. I was a man at the time, so it was considered straight marriage. And the interviewer sort of very shrewdly trying to figure out, asked us all kind of questions, where did we meet, this kind of thing. So does that interview process help at all? Does it still go on? I don't know if the interview process still happens, but does that interview process help, and how sensitive does that interviewer need to be these days to LGBT rights, LGBT marriage, that kind of thing?
The interview process definitely goes on. My experience is that the staff at the USCIS office in Chicago have improved greatly in their sensitivities to a lot of different issues, not just LGBT issues. I think if I was taking a case, this is going to be new for the officers. They haven't seen same-sex marriage interviews before. They're getting special training for it. But as the lawyer representing those clients, it's your job to educate them to the extent that they don't know about it. I think by and large the officers in Chicago are pretty liberal-minded people. They're open to the possibilities, but we still have to help them along.
Any more questions? I know that there are some colleagues in the immigration world who are expecting the immigration officer to be referred to the other person as your spouse or your wife or your husband, and they're going to raise hell if they don't use the terms properly. But anyway, any more questions? Yes?
So I heard that the previous marriage may affect the same-sex marriage. So I have a similar case because they both were married with opposite sex. So one of them even has a child. So will that consider some kind of shared marriage for the immigration point of view for the same-sex couple?
I mean, not necessarily. What's important when the couple goes to see an immigration practitioner is to get all the background information relating to all marriages and all divorces in the past. So I'm just saying that it can raise a red flag or question mark for USCIS, but it does not necessarily mean that if the person had an opposite sex marriage in the past, that will equal a denial by any means.
This is where hardship assessment would be a really good thing. Because what you do in the interview process with the family is you dissect each marriage and you look at the emotional components of what brought them together, what separated them in the marriage, and what life process brought the couple together. So you explain all that within the hardship. So whoever's reading that along with the legal documentation are able then to get a big picture idea and a narrative of what has gone on in the individual's lives.
I just want to follow up. I think timing is important too. If both divorces, if both partners or spouses now had their divorce right before they got remarried, they're going to be a little more cynical about whether that prior marriage was phony. If it was a while ago and you can demonstrate that that person underwent a coming out process that took time, and they can document it with their Facebook pages or other things, then you're going to have a better argument that that prior marriage wasn't a phony marriage, and especially if they had a child together. Most people don't have children just to satisfy immigration, and the marriage is genuine. It's been known to happen, but it's pretty rare.
My question is, if people kind of rush out now to do this, will this trigger a deportation if they don't get a lawyer and do it right? If someone from Chicago right now goes and tries to marry their partner in Iowa, will this trigger anything?
We don't know. Again, it's going to depend on whether or not they have a liberal interpretation of the celebration rule or not. I'm advising people that I've talked to hold off yet if they're living in Illinois and they're planning to return to Illinois to live. Let's let other people go first, especially if they don't have a reason why they need to, and if the foreign national is already not in legal status in the United States, they're going to be much more exposed to a potential removal hearing if it's not approved. That said, I think what we've seen since the Windsor decision was issued seems to be progressing in the right direction, even for states where marriage is not currently recognized. And the other reason I'm telling people, because I'm in Illinois, to wait, is we may have same-sex marriage legal here soon, hopefully. And if we do, just waiting a couple months will solve a lot of potential problems and worry.
I mean, my main concern is if they're not documented, will going to apply for a license trigger?
A license, no.
Okay.
But an immigration case, maybe, if it's not approved.
I actually have a client, a couple, same-sex couple, and they just rushed to get married in Minnesota. They have some traveling plans. The foreign spouse has a visa that expires next year. So I said, don't rush into going and get your immigration petition. Let the marriage season go on the honeymoon and make a celebration, make a reception, take your time, document your post-marriage situation, and then go and apply for it. They have the luxury of time because the foreign national is on a visa that will not expire for a while. But if there's a case where somebody is facing deportation, that's a whole different ballgame altogether.
Could you explain a little bit more about the best way immigration attorneys can determine whether a U visa or a VAWA petition would be applicable for LGBTQ members? Because I know there's hardship factors and then there are the VAWA self-petition factors. And so I would just like a little bit more information about that.
I can take a stab at it, you guys can jump in. So the U visa is a non-immigrant visa that's available to people who have been victims of certain crimes and who have assisted law enforcement agents in the investigation or prosecution of the crime. Important to note that the crime does not have to lead to a conviction. Simply calling the police and reporting the crime can satisfy the helping law enforcement agents. The statute has a laundry list of crimes that make a person potentially eligible for a U visa. Domestic violence, felonious assault, kidnapping, sexual assault, etc., etc. And it includes attempts or conspiracy to commit that crime, and not just commit the commission of the actual crime. So the U visa, let's say there's a couple who, for some reason, is unable, a same-sex couple who is, for some reason, unable to get married, for whatever host of reasons. Either they can't make their way to a jurisdiction that allows same-sex marriages because of mobility issues, health issues, financial issues, whatever the case may be. It's so important for that couple to go speak to an immigration attorney so that we can evaluate all potential options for that individual. And one of the questions that we ask in our office is, have you ever had to call the police for any reason whatsoever? And if they say yes, we ask why, and we look into the potential for the U visa. The VAWA self-petition is available to men or women who have been subject to domestic violence, extreme cruelty by either a U.S. citizen or a lawful permanent resident spouse. They have to prove that they cohabitated or married to that spouse, or if they're divorced now, that VAWA self-petition has to be filed within 2 years of the finality, the final adjudication of that divorce. That's another potential option for LGBT individuals as well.
Or if you're a child who's been abused by either a parent or
Right.
a step-parent, and that happens a lot with LGBT kids. So we have to take that into account. Also, I want to say the U visa, it's a nice thing if you have the facts, but it requires the cooperation of either the police or the prosecutor to sign off on the form to say you really helped them. So if you don't have that, it may not be an option, even if you did call the police.
Right. That certification is integral to a U visa application. If there's no signing off by law enforcement that the person is helpful or will be helpful, there's no U visa. But luckily in Chicago or in Cook County suburbs, the law enforcement agents are really well versed in U visa and they are great about issuing it. It's the outlying suburbs where we have more issues. DuPage County has been very problematic, especially Will County, McHenry. No, I've actually seen more and more from McHenry and also from Lake County as well. But the U visa is a really, really great option. If approved, it's approved for 4 years, and the individual gets a work permit. And after 3 years of being in U visa status, that individual can seek permanent residence in the United States.
One thing before we wrap this up is I noticed we didn't really talk, and it was not intentionally, about transsexuals and immigration. I know there are some very established rules about transsexuals and what the rules that we follow. Do you want to talk about it? Anyone make a comment?
I believe it was in April of 2012, USCIS issued guidance specifically that dealt with adjudicating visa petitions where a transgender spouse was involved. Basically what that guidance said was that a spousal petition would be approved if the transgender spouse was able to provide documentation, identity documentation in the affirmed gender, or a medical certification in the affirmed gender. If that didn't, if the individual can prove that, because let's say he or she had not taken any medical steps to transitioning into the affirmed gender, then it would be denied. Now with Windsor, transgender identified people who have not taken those medical steps to transitioning to their affirmed gender can have their U.S. citizen or permanent resident spouse petition for them. The thing to know, however, is that if the petition is approved and the green card is approved, they're considered to be a same-sex marriage because the individual hasn't transitioned completely, right? And whatever green card is going to be issued in the biological gender and not in the affirmed gender until the individual can provide documentation to USCIS.
For a trans person who's made the complete transition and has been able to get a change in birth certificate, the case that caused the USCIS to change their policy is called Matter of Lobo. And basically they got around the prohibition on same-sex marriage. This was a North Carolina case. Shockingly, North Carolina does allow the birth certificate to be changed. And they said, well, it's not a same-sex marriage. The birth certificate says that the sex is opposite. So that's how they got around it, and that was before the Windsor case was decided.
What about states like Ohio and Texas where they say that the gender that you were born into, that your DNA still makes you, whether you've had the sex change operation or not, you're still...
Well, I think as Vanessa said, then you need to rely on the Windsor case and the fact that it may be considered a same-sex marriage, and if that's what you need to get your immigration, even though it may not be ideally what you want because you consider yourself to have transitioned, you have to be pragmatic about it. But we now have an avenue, possibly, with the Windsor case that allows that person to get an immigration benefit, even if it's miscategorized.
We're also providing the medical documentation that the individual has transitioned to the affirmed gender. That's another route. If the state where you live will not issue you a birth certificate.
Thanks, Vanessa. Any one last comment you want to make before wrapping it up? If not, that's fine. Any questions?